The Second Amendment is a fairly popular amendment. The Third Amendment, much less so. The full text of the Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Article 1, Section 23 of the Texas Constitution reads, "Every citizen shall have the right to keep and bear arms in the lawful defense of himself or the state. But the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime." The Third Amendment reads, "No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." The Third Amendment to the U.S. Constitution is the only amendment that has never been litigated at the U.S. Supreme Court, and is certainly far less popular than its fellow amendments, particularly ones like the First and Second Amendments. However, according to Radley Balko in his book Rise of the Warrior Cop, at the time of its ratification, the quartering of soldiers in private homes was very much on the Founding Fathers' minds due to abuses they had suffered at the hands of the British as colonists. Quartering of troops in homes had its roots in the Norman conquest in England, when the English king, in order to raise an army, conscripted criminals and convicts, gave them guns, and then required the locals to house them. Suffice to say, quartering of troops was as unpopular in England as it was in the colonies. However, the British Army was far less willing to respect the colonists' disdain for the practice as they might have back home. While almost forgotten as an amendment, it remains part of the Bill of Rights and, further, is also found in the Texas Constitution, Article 1, Section 25. In more recent times, the Third Amendment has sometimes been used as support for privacy and the exclusion of government in one's own home.